Arbitration agreement, visualized. When parties agree to arbitrate their disputes, they give up the right to have those disputes decided by a national court. Instead, they agree to settle their disagreements privately, outside of the legal system. An arbitration agreement is an agreement between the disputing parties in a legal relationship to refer a current or future dispute to the jurisdiction of an independent tribunal, which would resolve the problem in a way that is binding on all parties. The following conditions must be met for an arbitration agreement to be valid and effective. First, the agreement must be in writing. Second, it must be related to a current and future disputes. Third, the dispute must arise out of a legal relationship between the parties, whether contractual or not. Fourth, the parties to the agreement must have the legal capacity and consent to sign and enter into contracts. Fifth, the subject matter must be capable of being settled by arbitration. And sixth, the arbitration agreement must be valid under the law to which the parties have subjected it. In their arbitration agreement, the parties give the arbitrators the power to decide the dispute. Therefore, the parties create their own private system of justice by choosing the rules that will govern the procedure, the location of the arbitration, the language of the arbitration, the composition of the tribunal, and the institution that will manage the arbitration. The parties' arbitration agreement is usually a clause in the commercial contract or a later submission agreement to arbitrate a dispute that has already occurred. However, in practice, submission agreements are uncommon because once a dispute arises, the parties often cannot agree on anything. For that reason, it is better to agree to arbitrate at the beginning of the relationship when the parties are still on good terms.